Welcome to The Workplace, a podcast by CalChamber. I'm Matthew Roberts, Associate General Counsel for Labor and Employment with the California Chamber of Commerce. Hello, listeners! The legislative session has finally come to a close, and thanks to outstanding advocacy work by CalChamber's policy team, many bills we opposed throughout the year were not enacted. However, in today's episode, we will focus on a major bill, SB 399, that was signed into law by Governor Newsom on September 27th this year. SB 399 limits an employer's ability to hold mandatory meetings with its workers if the subject matter of the meeting involves political or religious matters. To discuss the intricacies of this bill, as well as additional considerations around employer political speech, we welcome back two guests to the show. First, Erika Barbara, CalChamber's Senior Employment Law Counsel, joins us. Thanks for being here, Erika.
Hi, Matt. Thanks for having me on the podcast today.
And second, we say hello to CalChamber's Employment Law Subject Matter Expert, Vanessa Greene. Vanessa, thanks for joining me today as well.
Thanks, Matthew. Nice to be here.
Well, as always on the show, we have a lot to unpack today. So, Erika, let's start with you and the basics of SB 399. Generally, for our listeners, what new rules does this law impose on employers?
So, on a basic level, SB 399 prohibits all employers, regardless of size, from taking an adverse action against an employee, which could be a termination, a write-up, or some other negative consequence, because the employee declines to hear the employer's political or religious message. And this can happen one of two ways. One, the employee declines to attend an employer-sponsored meeting, or two, the employee affirmatively declines to participate in, receive, or listen to any communications from the employer or the employer's agents about the employer's opinion on either political or religious matters. And the law also includes a wage and hour requirement. So if an employee is on the clock during an employer-sponsored meeting and declines to attend the meeting, the employee must be paid during the time that the meeting takes place, even if they don't attend. So in addition to avoiding any adverse actions against an employee for declining to attend one of these meetings, the employer must also continue to pay the employee while the meeting is held.
So then I think the largest question for all of us, me included, is what do we mean when we talk about quote unquote political or quote unquote religious matters for the purposes of SB 399?
Yeah, so both of these terms, political and religious matters, are defined in the law, but they're defined very broadly, which could create some confusion for employers. So political matters is defined as any matter relating to elections for political office, political parties, legislation, regulations, and the decision to join or support any political party or political or labor organization. And religious matters is defined as matters relating to religious affiliation and practice, as well as the decision to join or support any religious organization or association. Now, the fact that political matters is defined to include support for a labor organization is likely going to cause concern for employers. And that's because for decades, employers have been able to hold mandatory meetings with employees to discuss the employer's opinion on unionization and labor organization, but this bill now undermines that longstanding practice. So as a result, employers who are looking to discuss opinions on unionization efforts with employees should consult with legal counsel now to tailor any such messages to comply with the requirements of SB 399.
Yeah, and I think that's a major change, right? That's really upended, as you said, decades of longstanding practice where, employers are not coercing or otherwise taking matters into their own hands regarding whether or not an employee joins a labor organization, but they do have the ability to say, employees, here's what's going to happen if you do. Here's our opinions on the labor organizations themselves, and at least give the employer the opportunity to provide their side of this. That has been a longstanding practice. Now, you mentioned this new law applies to employers of all sizes. Are there any exemptions from this new law?
There are, but there are only a few, and they are narrowly tailored. So, for example, certain religious corporations and political organizations may be exempt from the law if they qualify under the law and their speech relates to the underlying mission and beliefs of the organization. In addition, the law does not prohibit employers from carrying out communications or training that is required by law, or communications that are necessary for employees to perform their job duties. But generally, there are very few exemptions, and the law will apply to most employers.
And then I think the last question for us is, when do all these rules take effect, Erika?
Always important to know when you have to start complying with the new law. This law goes into effect on January 1st of 2025.
All right. Thank you, Erika. And I also think really an interesting development to watch is that California is not alone, nor was it the first to enact a law similar to SB 399. In fact, several other states, including Minnesota, Connecticut, and Illinois, have passed similar laws, but all of which are now subject to ongoing litigation that may ultimately invalidate those laws. So listeners out there, if you are impacted by SB 399, as Erika said, it covers everybody here in the state, then stay tuned to see what happens here in California. All right, let's shift gears. Presently, employers do not have to worry about the specific prohibitions of SB 399 for this upcoming election cycle in November because, Erika, as you said, it does not take effect until January 1st, so after this election cycle. But Vanessa, let's bring you in then to discuss how existing law impacts employers during this election cycle. That is, what ability does an employer have to provide political related messaging to their employees for this cycle?
Great question, Matt. So employers can still do a few things here. Let's look at what's allowed. So what they can do is they can communicate with their employees families, their stockholders about the company's position on state legislation and regulations or ballot measures. So that could look like an employer encouraging employees to either support or oppose these issues. And then also could look like an employer who's informing their employees and letting them know how these issues might impact the company and everybody connected to it. But when it comes to getting the word out, employers have options. They need to be careful, though. So they can use things like their internal mail system. They have an internal way to communicate, like email, even regular mail. They can use bulletin boards. They can use phone messages. But where they need to be careful is no political messaging in payroll envelopes. So paycheck stuffers are a no-go.
So this is good news for employers, at least through this election cycle, in that we have the ability to put our message out there. And there may be a number of political candidates, or as there always is in every election, a number of ballot initiatives that might impact our employers out there. They have the ability to spread this message. Now, although SB 399 is not in effect as of yet, again, until January 1st of 2025, are there still other rules, Vanessa, that employers should be concerned about when we handle political speech in the workplace?
Of course there are, Matt. This is California. When are we not concerned about stuff? So there are some important restrictions that employers need to follow. They can't control or direct an employee's political activities by threatening, for example, the employee's job if the employee is doing something politically that the employer doesn't like. It's also really important that employers avoid things like rewarding or punishing employees based on their political beliefs or activities, or even threatening to do things like that. And employers also can't coerce employees into supporting or opposing specific ballot measures. And then, like I mentioned earlier, no political messaging in payroll envelopes. And on top of that, there are some types of speech in the workplace that are legally protected and can't be prohibited. So things like collective organizing or discussions about employment conditions. Employers cannot prohibit employees from talking about, for example, voting for a particular candidate or supporting a particular law that the employees believe will help improve working conditions, right? So we can't take action against them for things like that tie into their employment conditions and their work environment.
Excellent. Well, thank you, Vanessa. And I think, of course, really the thrust of the whole episode today is, we can continue to do stuff as of now. We need to be careful with the provisions of SB 399 going forward. But as always, stay tuned for any kind of additional litigation developments. And as another national election rapidly approaches, I want to give many thanks to the two of you, especially for spending some time with me on this show today. So, Erika and Vanessa, thank you so much for being here.
Thanks, Matt. It's always a pleasure.
Oh, you're welcome, Matt. Yes, our pleasure.
And thank you, listeners, for joining this discussion on the workplace. Please share and subscribe to CalChamber's podcast by visiting calchamber.com.